Yes, I am Jennifer Walker Gates, immigration attorney in Austin, Texas with Walker Gates Bella. I'm here today in this video to talk about adjustment of status under 245I. 245I is a section of immigration law that allows people to adjust status in the United States even when they enter the country without permission. Or if they have worked without permission or otherwise violated some provision of their status. This is really, really important for so many people because I have people asking all the time, is there a way to become a resident in the United States without leaving the United States? Is there a way to just take care of my process here instead of having to go back to my home country or send my spouse back to their home country? That is such a stressful process. The consular process is hard, it's expensive, there's a waiver involved, and most importantly, it's just nerve-wracking because people have to leave the United States. And when they leave, they don't have already permission. They don't know 100% that they're going to be approved and allowed to come back. It's a huge leap of faith to take that trip. So this video, it's going to talk about 245I, and that's the sort of shorthand that we use to talk about this type of case, 245I. And it's pretty unusual for people to qualify for 245I anymore. It's become really outdated. It's something that sunsetted in the law a long time ago, so not that many people qualify anymore, but sometimes people do qualify and they don't realize it. And so if that applies to you, it's also really important to know. So I have some slides that I'm going to share with you, and I will walk you through who qualifies, under what circumstances, how it works, and then we'll go through some examples. Okay, so this is the slideshow. We're going to be talking about, like I said, adjustment of status under 245I, going through the overview and some examples. I want to turn off those subtitles. Let's see. Subtitle settings. More settings. Cancel. Okay, maybe this will work. Alrighty, so what is 245I? 245I is a provision of the immigration law that is also often referred to as the LIFE Act. LIFE Act stands for Legal Immigration and Family Equity Act. It was a provision passed by Congress in the 90s to allow family members to be together in the United States as much as possible. Imagine that. It was a family unity provision in the immigration law. And what 245I did and does is enable qualifying individuals to apply for adjustment of status in the USA, even though they entered without permission, worked without permission, or failed to maintain lawful status in the United States. Most people who meet those criteria or fall under those descriptions are not eligible to adjust status. So 245I applies to a narrow subset of immigrants who enter the United States without permission or otherwise violated status, but are still eligible to apply for adjustment of status here and don't have to do the consular process back in their home country. For most people, 245I eliminates the requirement for a waiver and also allows them to become permanent residents without leaving the USA. Now, here are the requirements for 245I adjustment of status. First, you must be a beneficiary of a labor certification application or an I-130 or I-140 petition that was filed on or before April 30th of 2001. Okay, this is the big requirement that most people can't meet. You have to have had somebody, either a relative or an employer, file a petition for you before that critical date of April 30th, 2001. Now, we'll talk more about who qualifies as a beneficiary. Maybe the petition wasn't filed directly for you. Maybe it was filed for one of your parents or your spouse. And so we'll talk more in detail about that and go through some examples. But basically, suffice it to say, if somebody didn't file a petition for you back before April 30th, 2001, you're not going to qualify for 245I adjustment. Now, number two, if that petition, the I-130 or I-140, was filed before April 30th, 2001, but after January 1st of 1998, between those two dates, then there's a second requirement of proving that you were physically present in the United States December 21st of 2000, on or before December 21st of the year 2000. If you can't prove that you were here on or before that date, then even if you have that old I-130, then you're not going to qualify for 245I adjustment. Number three, you have to be otherwise eligible to become a permanent resident. So that means no disqualifying criminal charges, no past fraud, no past permanent bars, deportations, anything like that that would prohibit you from otherwise becoming a lawful permanent resident. And fourth, you have to file a supplement I-45A when you file your application packet, along with a penalty fee. The penalty fee is for that unlawful entry. It's what you have to do to qualify for 245I. If you otherwise qualify, you have to pay that $1,000 penalty fee to be able to get your residency. Now let's talk about who qualifies as a beneficiary for purposes of 245I. In order to qualify as a beneficiary, you have to be either the named beneficiary on that I-130 petition. Okay, you have to be either the person who is directly the beneficiary, or you have to be the spouse or ex-spouse of the person named on that I-130 petition, or be the son or daughter of the person named on that I-130 petition. And if you're the son or daughter, you have to show that when that I-130 was filed, you were unmarried and under the age of 21. Okay, so the spouses and minor children of those beneficiaries can also qualify for 245I adjustment in some circumstances. Now, for purposes of 245I, you don't have to become a resident based on that initial original petition that was filed for you. You can do that. When your priority date becomes current, you can adjust your status based on that original I-130. But a lot of times people end up having an alternative way to become a resident using a different petition. And that means that if you've aged out of that original petition, or you got married and somehow that original petition, because your petitioner was a lawful permanent resident, if you got married as the child of a lawful permanent resident, that original petition is not going to work. But you may still be eligible based on another different petition. So in these instances, I think it's really helpful to go through examples so that I can help kind of illustrate how this works. It's very confusing, so bear with me. Okay, so example number one. Let's say it's January 1997. Julio and Ana get married. They are both from Mexico. They live in Mexico in their hometown. And so they get married, they have a big wedding. Everything's wonderful and happy. And that is how the family is founded for Julio and Ana. Now, that is in January of 1997, okay? In December of that same year, Ana's father, who is a US citizen, let's say he just got naturalized, maybe he became a resident through the amnesty in the late 80s, and then he got naturalized in December of 97, and then he files an I-130 for his daughter, Ana, okay? And since he is a US citizen, he can do that even though she's married. Now, if he were a lawful permanent resident, he couldn't do it. The I-130 wouldn't be approvable because she's married. So he's a US citizen, he files the I-130 for Ana. The next year, in 1998, Julio and Ana immigrate to the United States. They both enter without permission. They don't have visas. They just come to be reunited with their family, Ana's father and mother maybe, and whoever else may be here. Whatever the case, they come across the border like so many millions have without permission, and they don't return to Mexico. They establish their lives in the United States and they stay. Sadly, in the year 2000, Julio and Ana get divorced. okay? Then a couple of years later, Julio remarries. He remarries a woman named Claudia, who is a US citizen. Now remember, the petition that was filed when Julio and Ana were married was for Ana, it wasn't for Julio. However, even though that's the case, if Claudia files an I-130 for Julio as a US citizen filing for her husband, Julio, even though he entered without permission to the United States, he can still adjust status because of that I-130 that was filed for his wife when he was married previously. Okay, so that may seem unfair, that even after divorce, I mean, it could have been that Julio even cheated on Ana with Claudia, and now he gets to benefit from that I-130. But such is immigration law, and this is how it works. Julio is eligible to adjust status based on his marriage to Claudia using the I-130 that was filed for his previous wife. So long as he's otherwise eligible, he pays that $1,000 penalty fee, and he proves that he was married to Ana when her father filed that petition for her. Now, let's do another example, okay? Let's say, once again, it's January of '97, and Julio and Ana get married. My dog is rolling around on the floor in here, so you may hear some weird noises, and she's scratching her back. So you may see her in the camera, you may hear her, sorry about that. That's how life in the pandemic works. Okay, so example 2. We're back in '97, Julio and Ana get married, they're both in Mexico, they both live in their hometown. In November of that year, they have a baby, April. Okay, they have little baby April born in Mexico. Then when April's a month old, in December of '97, Ana's sister, Carmen, who is a US citizen, files a petition for Ana. Okay, now this petition filed for Ana by her sister is going to cover Ana, Julio, and April. Okay, so all 3 of them really get to be beneficiaries of that petition. In 1998, Julio, Ana, and April immigrate to the United States. They enter without permission, and they don't leave. They don't return to Mexico. In 2017, okay, April gets married to a US citizen, Jorge. Now, remember, April was born in 1997, so she's 20 at this time. Let's say that petition filed by Carmen still hasn't allowed her to get her residency because the priority dates, as we know, are backed way up for Mexicans especially. This is going to be a new other way for Ana to be able to adjust status, okay? If Jorge files a petition for Ana, an I-130 petition for his wife, then she can adjust status in the United States, even though she entered without permission, because of that earlier I-130 filed for her mom by her tia, Carmen. And again, she has to prove that she's otherwise eligible. She has to pay that $1,000 penalty fee. She has to prove that she was under 21 and unmarried when that I-130 was filed for her mom. She has to prove the family relationship with her mom and her tia. But if she does all that, then she's good to go, okay? Example 3, we're back in '97. Julio and Ana get married again. They're from Mexico. They live in their hometown. In 1998, they immigrate to the United States, okay? Petition still hasn't been filed. They immigrate to the United States. They enter without permission. They don't return to Mexico. Then they have a baby in the United States in January 1999. April's born here on this side of the border. So she's a US citizen. April 30th of 2001, that critical date, Ana's dad, who is a US citizen, files an I-130 for Ana, okay? So he gets that petition filed just in the nick of time on that critical date. And when they get that receipt notice from the Department of Homeland Security, it has that date, April 30th, 2001, as the priority date. It's very important that they have that. Now, when April turns 21 on January 1st of 2020, she becomes eligible to file a petition for her mom and her dad, okay? Now that she's 21, she can file an I-130 petition for her mom and dad, and they can adjust status because of the earlier I-130 that was filed for Ana by her dad, okay? It covers Ana, it covers Julio. And now that April, their US citizen child, is 21, she can be their new petitioner. Again, they have to prove they're otherwise eligible to adjust status. They have to pay that $1,000 penalty fee, each one. They also, because the petition was filed after January 1st of 1998, they have to prove that they were physically present in the United States on December 21st of 2000. Okay, so they have to have some kind of documentation to show that they were here on or before that date. I don't think that should be hard, since their daughter's birth certificate will be dated prior to that. So that is how a number of our clients have handled their 245I cases. And okay, now my cat's making a weird noise. So if you hear weird noises from my pets, I apologize. But yes, now the cat is making little squeaky meow noises. So it's just a menagerie around here. All right. This is the fourth and final example of how 245I can work in a case, okay? Let's say it's October of 1996. Anna's father is a US citizen. He files an I-130 for her. At that time, in October of 96, she's 22. Anna is 22 years old, and she is unmarried, okay? So she is an adult, but she's not married. Later, she gets married. In 1998, she gets married to Julio. Let's say they get married in the United States. They're here. They met here. They're from Mexico, both of them, both entered without permission, but they got married in the United States. They've been here for several years, and they've never left, okay? In April of 2021, which is the month we're in now, the date for the category of Anna's father's petition is finally current, okay? So they don't need another petitioner. They don't need a US citizen child who's 21. They can adjust status based on the petition filed by Anna's father. First, Anna is the direct beneficiary. Now, in this case, Anna and Julio were not married at the time that the dad filed that. So in this case, Julio would be called an after-acquired spouse. However, he gets to adjust status too, okay? What about Julio? We know Anna gets to adjust status through that petition because it was filed for her. But what about her husband? He does too, but he has to file as the dependent of Anna, okay? So he has to file his application either at the same time as Anna's or within 6 months of her becoming a lawful permanent resident. And if he doesn't file in time, he will lose the opportunity to do that. So even though he was not married to Anna at the time that petition was filed, he can still take advantage of that I-130 petition so long as Anna is becoming a resident through that original petition. This is not a case where Julio could benefit from an alternate petitioner. He would have to go through that original petition that was filed by the dad, but he can still take advantage of it, presuming, of course, that the dad is still alive and that he's otherwise eligible, he pays the fee, etc. Now, even if the petitioner was not alive, even if the petitioner had passed away, they may still be able to adjust status in that case. But that is a whole separate topic for a whole separate video. It's a rather complex process the way that works. And so we will be doing another video on that very soon. I hope this has helped clarify. You may need to watch this video a few times. It is a very confusing topic. And it is a wonderful benefit if 245I is available to you. So please reach out to us. If you have anyone in your family who has filed a petition for you, for your parents, we would be happy to take a look at that case and analyze your eligibility, your spouse's eligibilities, your children, because just like in the final example, how Julio was able to adjust, if the couple had had a child born in Mexico that was then brought to the United States, who was after acquired, they too could potentially file as a dependent. So 245I benefits can be very broad. They can be very generous. It was a very practical solution to, the kind of problem of people coming across the border without permission. It raises money for the federal government. You know, a lot of immigrants would gladly pay a $1,000 penalty fee. It's not an amnesty if you're paying a penalty fee. So this would be a really wonderful solution for Congress to enact again. But we will see what happens. We're hoping and working very hard to have some reforms passed in Congress so that our immigrant community can get legal and get lawful residency, travel home to see their loved ones and their family, contribute fully to the United States, and feel the security that they deserve after so many years and decades of making contributions in this country and not having lawful status. So I hope that this has helped. Please reach out to us. You can find us at walkergatesvela.com. If you go to our website, there's a button there where you can click to schedule a consultation with any of our lawyers. You can also click to call us there. You'll find our phone number there. You'll find emergency phone numbers there in case there is an emergency with an arrest or imminent deportation. And finally, subscribe. Hit the subscribe button on our YouTube channel. We will be publishing lots of videos to keep you guys informed about your rights, your responsibilities, possible remedies for your immigration case. I hope this has helped. Thank you so much for your attention. Have a wonderful day. Thank you so much, and goodbye.